Welcome to this episode of SCL Talks, where we discuss termination this time. I am İdil Kurtbozoğlu, and I'll be hosting this video on behalf of SCL Turkey Board. We have a very experienced and a very familiar lawyer in the area and in the field, Mr. Charles Blammer-Brown from Pinson Masons LLP, London. Charles is currently representing clients in international arbitrations and before dispute boards on terminated projects in Turkey, Eastern Europe, CIS, and Africa, including roads, rail, airports, power plants, and renewables projects. Welcome, Charles, and thank you for your time and sharing your experience with us.
Thanks, Idil, and thank you to you and SCL Turkey for inviting me to participate in this excellent series of construction law films. It is a truly fantastic initiative.
Thank you. Charles, I personally know that you have a great deal of experience in the termination of FIDIC contracts all around the world. My first question will be in the form of a morning coffee talk. I suppose kicking things off, it would be good if you could clarify what we mean by termination.
It's a good question, Idil, and I'm conscious that termination is rare in practice. And as a result, in my experience, there can be a number of common misconceptions. And so I'll deal with two of those, if I may. I think the first common misconception is that termination is just a contractual right, governed solely by the terms of the contract. Now, yes, most contracts, including FIDIC, have detailed termination provisions, and a party may elect to terminate a contract pursuant to those provisions. However, there will often be an additional termination right under the governing law. So, for example, under many common law systems, there is a right at law to terminate for something called a repudiatory breach. And under English law, this is defined as a breach which goes to the root of the contract or substantially deprives the innocent party of the whole benefit of the contract. So the innocent party has the option of accepting this repudiation, thereby terminating the contract. And if it does, it may be able to claim different remedies, including a claim for loss of bargain damages, which might not be provided for under the contract termination provisions. Now, this concept of repudiatory breach is not generally something found in civil law jurisdictions, which themselves may have very different termination principles. For example, in certain jurisdictions, an administrative contract cannot be terminated without first going to court to determine a party's entitlement to terminate. Now, there is no such concept of administrative contracts under English law and no such requirement to defer to the courts first. So my first point is to remember that a party's rights to terminate are not just governed by the contract. You need to check carefully any additional rights and principles under the relevant governing law and take advice on these. And then the second common misconception concerns the effect of termination on the contract itself, with an assumption that's often made that the contract is somehow ended or discharged. And that assumption, certainly under English law, is technically incorrect. Yes, following termination, the parties will be discharged from their primary obligations. For example, the contractor's obligation to perform the works, the employer's obligation to pay. But the parties will not be discharged from any secondary obligations that survive termination. For example, complying with the dispute resolution board proceedings. So following termination, I think the key point is the contract remains in place. The parties are simply discharged from their primary obligations.
Thank you. It is clear that termination involves a lot of legal considerations, but what about any commercial considerations of the parties that they should be aware of? Let's start with the employer.
Well, whenever I speak to clients thinking about terminating a contract, I always describe termination as being a zero-sum game. And what do I mean by this? Well, essentially, there is going to be a winner and a loser. There isn't a middle ground. You have one shot of terminating and getting it right. And certainly under common law systems, the consequences of terminating where you are later found not to have sufficient grounds to do so can be very serious. Now, a lot of my arbitrations involve state employers, for example, roads or rail departments, terminating international joint venture contractors in respect of very significant infrastructure projects. And these projects are often partly funded by the taxpayer. So political success can therefore be heavily linked in part to success of these projects. Terminating them can therefore give rise to a lot of unwanted public scrutiny and is an important consideration to bear in mind for those state employers. For projects which are financed through the banks and other institutional lending, while termination is a step which needs to be carefully thought through in terms of the impact of future financing, not only for the current project, but also financing from the same institutions for other projects. Any step to terminate should therefore be done in close consultation and agreement with those lenders. Finally, I would add that there is a need sometimes to be more realistic about the reasons for perceived performance failings of the contractor. Contractors are, of course, not generally in the business of performing badly. There will usually be a very good reason why they're struggling to meet the budget program requirements. And a lot of this can stem from actually whether these requirements are viable in the first place. So you may wish to terminate the current contractor as an employer, but if these requirements are actually unrealistic and the cause of the problems, you are unlikely to fare any better with a replacement contractor.
Thanks, Charles. And briefly, what wider considerations are there for contractors thinking of terminating a contract?
Well, one of the first things an employer will likely do faced with a contractor terminating or threatening to terminate will be to make a call on the bonds. And this can be a very serious problem for a contractor, depending on the applicable law and the nature of a bond instrument. For example, whether it is on demand or a guarantee bond, it may be difficult to prevent a call being made or the banks from paying out. And another serious consideration is that termination could, of course, be an acrimonious step. It can have the potential to ruin relationships with the employer, and it might be a risk worth taking for a contractor working in a new market for the first time with a new employer. But what about a contractor working in its primary market for an employer who is dependent on a large portion of its business? And a final consideration I would flag is that used correctly, termination can actually be a very effective tool for a contractor to extract itself from a loss-making or problematic contract. And I think it can be a very effective contract management tool.
Let's assume a party has considered the legal and commercial implications and concluded that it has grounds to terminate and wishes to do so. What should it do next?
Well, this will depend in part on whether the party wishes to terminate under the contract or at law and any relevant contract or legal requirements. If a party wishes to terminate under the contract, it's really important it follows the contract process for doing so, including following the notice requirements. And the contract may include very detailed requirements around the form and content of this notice. All too often, in my experience, these requirements are just not strictly followed. And the consequences, certainly under common law, can be very serious in that the purported termination is then found to be invalid, rendering the terminating party in repudiatory breach of the contract itself. And then the original defaulting party could then accept this repudiatory breach and terminate the contract, which is, of course, not a position you want to find yourself in.
Thank you, Charles. What are the types of termination of a FIDIC contract?
Well, I think the FIDIC contracts include a pretty comprehensive list of all the termination grounds you might expect. There are separate lists for the employer and contractor. In terms of the employer's grounds, well, these include the contractor's failure to comply with a subclause 15.1 notice to correct. Now, the issue here is that notice to correct can be issued for any failure by the contractor to comply with its obligations. And there's no qualification as to whether it's material or substantial. Now, the position has been clarified under English law in the case of OHL and the Attorney General for Gibraltar, in which the court did find that the clause should be construed as only permitting termination for significant or substantial breaches. Now, Other grounds include the contractor's abandonment of the works and the contractor's failure to proceed with the works with due expedition and without delay. And the latter ground can be quite difficult to establish in practice. The contractor will say, well, I've got an extension of time to justify this delay. And even if there is an excusable delay, how much delay must there be to entitle the employer to terminate? Is it a day? Is it a month? Is it a year? Well, I think it will very much depend on the facts and context. In terms of the contractor's ground for termination, well, these include the engineer's failure to issue a relevant payment certificate within 56 days after receiving a statement. Now, what if the statement was for a very small amount? Could the contractor still terminate for the engineer's failure to issue this payment certificate? On the express wording of the contract, that would appear to be the case. But will the applicable law permit such an interpretation? Also, to terminate under this ground, the contractor has to give 14 days notice. Well, the engineer is probably going to be prompted to issue a payment certificate. But what if the engineer's assessment in this payment certificate isn't a fair one? Could the contractor still terminate? The clause doesn't say so, but there may be room for argument. So as you can see, whilst the contract provides grounds for either party to terminate, whether these grounds are met will also very much depend on the analysis of the facts and the relevant context, as well as the applicable law.
Charles, how much would you weigh the FIDIC experience over the governing law when it comes to resolving termination disputes?
That's a great question. And I think you really do need a combination of both. You obviously need, and I hope my presentation has emphasized the point, good local law advice. At the same time, particularly before international tribunals, I think you really do need recognized specialist international construction lawyers with familiarity of termination disputes in multiple jurisdictions. And importantly, therefore, an ability to translate and present the local law advice into principles an international tribunal will buy into. So in my experience, building a team made up of both really is the winning formula.
Charles, thank you very much for your valuable insights. And please accept my thanks on behalf of the SCL Turkey board as well. This concludes our very fruitful termination session, and we hope to see all of you in our next talks videos on yet another major topic. Thank you for watching.